Good afternoon and welcome to a meeting of the Regulation Subcommittee of the California Paraprofessional Program Working Group. I will begin by taking roll. Hartston.
Here.
Kirkmeyer.
Here.
Sarush.
Here.
Thank you. Everyone is here. We'll look to see if there's anyone who wants to make comment. We have a number of attendees. If anyone would like to make a comment, please raise your hand in the Zoom meeting. We'll give you the opportunity to speak. We have one person. So I'll go ahead and I think we can, do you want me to give 3 minutes?
Yes, thank you.
Good.
Okay. Joshua Lee.
Hello, thank you for allowing me to make a comment. I'm with CALDA, the Association of Legal Document Assistants, and so I think it was the last week or the week before when it was discussion of things that in the family law, under the family law grouping that would be done is prenuptial and postnuptial agreements. And I didn't know if that was specifically, if that was saying that the paraprofessional would not be able to prepare those documents or could not represent a client with in terms of those matters. And the reason I was wondering is because as LDAs currently can do that, and it kind of seems like a step backwards for a LDA to be able to do something currently that a paraprofessional wouldn't be able to do. And I was just wanted to know what your thoughts were about that. Thank you.
Linda, you're on mute.
Another meeting of the Family Law Subcommittee has been scheduled. It's going to be posted probably later today or tomorrow, and that's going to be on June 29th. So if you'd like to address that subcommittee at that time, you're welcome to do that.
Is that it for public comment?
No, we have 2 more people. We Ashad Muradian.
Yes. Can you hear me?
Yes.
Thank you. So my name is Ashad Muradian. I'm a specialist in legal ethics and state bar matter representation. And I have a question regarding the proposals for the educational requirements, which I believe is the province of this committee. I noted that there is, for example, family law 9 credit hours, which would include family law and procedure, advanced family law and procedure. But I recall from earlier meetings that there was also an attempt made to actually develop a curriculum with some law schools. So I'd like to know if that has moved any further or if the committee is taking a different path. And then the second issue would be as to those pre-existing paralegals and other paraprofessionals that could waive into requirements. Are there any more specificity on how that might occur where someone, let's say, who's a paralegal would be able to get part of their prerequisites completed because they've been a paralegal for 10 years, for example? That's all. Thank you very much.
Okay, and we have
Linda, do
one.
you want to just clarify that is actually not the
Yeah,
purview of
that,
this particular
yeah, yes, that's the purview of the licensing subcommittee. And initial requirements have been adopted, and I can, if you want to email me, I can send you what the requirements were that were adopted. And there are additional, there's another recommendation coming from the licensing subcommittee to the full working group at the next meeting on June 25th.
Okay.
And we have Stephen Fleischman.
Hi, I've shared a bunch of emails with Greg and Brady. I don't know if you guys wanted to invite me into this meeting or not. Leah, your call, whatever you want to do.
Well, I think we got a message last time from Brady that we actually shouldn't be doing that for folks who are not members of the subcommittee
In
on the working group.
You're on mute, Brady. Or you're not on mute, but we can't hear you.
Do you want to go ahead, Stephen? What worse, Brady's not.
You think it's okay? So Brady, are you indicating that it's okay to invite him to join the group?
Okay, all right. Okay. Well, let's do that.
And we have another
Thank you,
public,
Brady.
we have another speaker, Angela Grijalva.
Hello, Angela Grijalva here. Thank you so much for this opportunity to speak. You know, I couldn't find the materials, the emails that were to be distributed. From my understanding from the last meeting, these were to be available. I'm on the website, I'm under the event, and I don't see them posted as agendas as active, accessible PDFs. I'm not sure where I would access those as a member of the public.
Yeah, we have not made those emails public. So it sounds like something that we need to do, Linda. And we're not going to be able to do that right now, Angela. Unfortunately, you will hear about them at this meeting.
All right.
Yeah.
And I'll always opine at the next one then. All right, thank y'all.
We don't have any other public speakers.
Okay. Should we look at our work plan for today and then just get into it?
Great.
Does that sound good? Okay. Let's see. 3. Okay, let me boost this up. So here's what we're hoping to get through today. These are the remaining rule issues that we have to deal with. We made some good progress last meeting on the mandatory disclosures, which we're calling now notice to consumer rule, which is rule 1.4.2. And we came to some consensus on 1.5.2 with the written agreement rule, but we're going to circle back, I think, today and reconsider that rule in the context of rule 1.4.3, the informed consent to representation rule. Hopefully we can hammer that out in about 30 minutes, I'm hoping, so that we can move on. I want to touch on, revisit rule 1.5. We had reserved the issue of contingency fee caps at Fariba's request so that she could revisit the 33 1/3% cap, which I think Steve Fleshman also provided feedback on and is suggesting that it be set at 25% instead. Then there are 3 more rules that we need to touch on because we received comments from Professor Moore on these rules, and we also just need to weigh in as a group on what the policy decision and recommendation is going to be from the subcommittee. And that is rule 1.5.3, the employment of disbarred, suspended, resigned, or involuntarily inactive attorneys or paraprofessionals in this case. The trial publicity rule, which Steve Fleshman has suggested that we reconsider adding now that we are envisioning that paraprofessionals will be permitted to provide full court representation, especially in family law matters where you might have highly publicized cases. And then Randy has some suggested amendments to rule 1.8.10, the sex with clients rules. I think they're actually excellent recommendations so that we are consistent with the rules that govern attorneys, because that's actually governed by not only our version of rule 1.8.10, but also a provision of the State Bar Act that's slightly different. And then I think we're going to try to move on to at least begin Brady's presentation on proposed statutory changes. But it's important, I think, for us to get through these rule topics so that we are ready to present the full set of rules by next Friday. I am going to endeavor after this meeting to capture all of the changes and send out a full set of rules tonight. And then I think staff will disseminate that to the full group and have them posted so that everyone has a week to at least look at what the full set of recommendations are from this group. Does that sound good to everyone for our plan? Okay,
Great.
so let's turn to Kim provided us with some suggested changes. I believe that's this. No, that's not that one. It's this version. Try again. Oh, yes, this is it. Okay, let me bump it up so everyone can see. I'm just going to put this on a separate page so we can see it all more easily. Okay, this is the written agreement rule that we essentially came to a consensus on last time. And then a version of the informed consent to representation rule that Amos had suggested with some of Kim's suggested changes. I think when we last left this topic, Randy had provided some guidance that I thought was helpful in trying to consider what perhaps should belong in the written agreement rule as opposed to the informed consent rule. And Randy, you might have to correct me if I'm misrepresenting exactly what you said, but I essentially understood it to mean we should consider a written agreement to be a contract for services. And so with that understanding, the mandatory provisions for that written agreement should probably follow that line of thinking. And as opposed to the informed consent, which is providing an account of the relevant circumstances to your client, as well as the actual and foreseeable adverse consequences of proceeding with representation by a paraprofessional. So what we're hoping to do is try to reduce the redundancy between these two rules in terms of disclosure, so that, especially so that the informed consent is clear and uncluttered, and it provides the client with all the vital information they need to make an informed decision. Does that sound right to everyone as a guiding principle?
So I agree. I'd like it to be clear and maybe cut down on repetition, but I don't agree if the intent is to substantially remove disclosures that we have all agreed on. The disclosures were selected and important. So I think we should stick with what we have and make changes to it as opposed to restarting with something else.
Does anyone else have any thoughts before we start? Okay, well, why don't we just go through some of the changes that that Kim included, and Kim, please feel free to let us know what your thinking is here. So turning to paragraph A, it looks like we are I think this is the language that I'm highlighting right now is what we agreed to last time as a group, that we would substitute this in, which is really in some ways paralleling the definition of what informed consent means, which is to provide the actual and reasonably foreseeable adverse consequences of proceeding. And the definition says course of action, and the course of action here is the engagement of a non-lawyer in this matter. And in this matter is important because it implies that the disclosures and the adverse actual and reasonably foreseeable adverse consequences is tailored to the matter and to the relevant circumstances. Is everyone in agreement that this should be the language in A?
So I agree, but we did lose some changes. I think it might have been unintentional, but maybe we can, I can tell you what the language was. I think we were just working off of different versions. So
Okay,
the actual
what language is, because I.
Okay, right after alternatives and before the added language, it said material risks, comma, including any.
Oh, okay, that was an inadvertent. So here, let me do this. Move this over here. Okay. Including any actual Okay.
And I don't know if it's substantive, but we also deleted, I think, the engagement at the end of that sentence. The engage with, so it previously said for foreseeable adverse consequences of proceeding with a non-lawyer in this matter. I don't know if we need the engagement, but it might be non-substantive.
I think it's actually more economical, and I don't think you lose anything by removing it. But does anyone else have a strong feeling about that? Okay, let's move that. Okay. Should we move on?
So I think non-lawyers should be bracketed. I would say a licensed paraprofessional, because that's who we're talking about here. But I realize that the name might be changed. But if you leave it non-lawyer generic, I don't know what other type of issues that raises. I mean, these are rules that are going to apply to paraprofessionals. So I would recommend specifying that that's what we're talking about.
Well, we did have some conversation about this at the last meeting, Andrew. I think it is intentional that it be non-lawyer, because the actual or reasonably foreseeable adverse consequences that at least the subcommittee wants to make sure that the client's aware of is those consequences that flow from the fact that you're not engaging a lawyer in this matter.
Sure, but aren't some of the disclosures predicated on what the licensed paraprofessional can do when you get down below, like to 4?
Yeah, I think this is in it. These disclosures are in addition to that disclosure, which is make sure you. Well, I won't speak for the subcommittee members. Actually, why don't you guys jump in?
Okay.
Would it be helpful to say with a paraprofessional, and then who is a non-lawyer, who's not a lawyer?
That's going to be stated in A1. I'm just trying to set the predicate for the rule. This is just a typical rule drafting technique. What are we talking about? We're talking about engaging a licensed paraprofessional. If there's a
Not a lawyer.
persuasive reason to include a generic term, law and lawyer, which would encapsulate people who are not licensed paraprofessionals, that's fine. I realize time is of the essence. I don't want to distract, but I don't understand why we're not saying who we're talking about.
Mhm.
So I agree with what Greg was saying, what we talked about last time. The persuasive reason, at least to me, is this is supposed to be a clear disclosure and explanation to a non-attorney, to the client, a lay person, basically explaining what the risks are. And so the more legalese we use or defined terms we use, the less effective it will be. So I think technically you're right. We could substitute that in and be correct, but in order to be clear and effective with a meaningful disclosure, I think a lay person's term and what we're really requiring in this rule is for the paraprofessional to explain what it means to be hiring a non-attorney in this matter. So I like it the way it is.
Amos, what if we did with a paraprofessional non-lawyer? Because I agree with you. That's why we wanted the word non-lawyer in there, is so it was very clear that, you know, these are why you have these, you know, consequences and alternatives that are needed. But I mean, I see where Andrew's coming from. So maybe just kind of to hit both. If we do paraprofessional non-lawyer for the individual to understand, do you think does that muddy it too much?
So I'm fine if you want to do that. I think the more we complicate it, the more we undermine what we're trying to do. But again, I don't think it's technically incorrect, and an attorney would be able to understand that.
So my question is this language that paraprofessionals will have to use verbatim, or as long as they say something that meets all these requirements, they have met?
Well, I am hoping that we come up with help, standard language forms. It's not going to be able to
Right.
be, you know, fill in the blanks. So I'm hoping, but that still to be
No,
determined.
that I understand that piece. I'm just saying, this particular stage we're at, these are just a paraprofessional could paraphrase, right? Whether we come up with standard forms or not. So again, I'm just trying to understand, are we doing guidelines or verbatim language?
It's not going to be verbatim language because it's an informed consent. So it's going to be, the language is going to be different depending on the relevant circumstances and the matter, and there's a,
Right.
so,
Reba,
but that being said, probably the best practice for a lot of paraprofessionals will be if we say you need to disclose the material risks of proceeding with a non-lawyer, they're going to use a lot of that language in their disclosures because they're going to want to make sure they're in compliance with the rules. So it is going to guide them in terms of what types of disclosures they need to be making in order to obtain informed consent in compliance.
For Reba, we'll get to your concern in the next sentence, and I have a suggested fix, which I think will address what you're driving at.
Thanks.
So where do we stand on this issue of non-lawyer? I'm not seeing, and maybe when we go through the actual subparts, it'll become clear, but it does seem that the disclosures that we have here do flow from the potential and actual foreseeable risks of proceeding with a non-lawyer. But I mean, number one is you have to say that you're not a lawyer. And two, they have to, and that there may be other choices out there, which includes seeking the services of a lawyer. So
Greg, just thinking about trying to get through all of this in 30 minutes, I think we should just parking lot that issue.
Okay, let's park it.
Yeah.
Yeah.
Move on.
I don't want to get waylaid by this language. But we'll note that, Andrew. Okay, so number one is a statement that they're not a lawyer, which is something that's included in the written agreement, I believe, somewhere. Yes, the licensed paraprofessional is not a lawyer, and it's included in the notice to consumer. The licensed paraprofessional is not a lawyer. Does a subcommittee want to include that here? I think it probably, makes sense. It seems like every communication that they're having with their prospective client is going to re-emphasize the point that they're not a lawyer. But
That's why I left it in when I edited it. I figured it was worth repeating.
Yeah.
In that informed consent, because that's almost the basis of the informed consent, right?
Yeah, everything flows from that.
Certainly a relevant circumstance. So if we want to meet the definition, I would think that would have to, without limitation, be disclosed here.
Yeah, and for Reba, this will be boilerplate. This will be something I'm sure that they'll just simply, it's a very simple statement. The
Yeah.
second,
I mean, it does raise the question if you want to disclose it in the other rule, but we don't have to go there now.
Okay.
Sorry, I have an issue with the sentence above at the end of A.
the
I
disclosure.
know we're trying to go fast, but I'm only raising things that are important. And so my suggested edit is to change the sentence to say the disclosures provided shall include, comma, but not be limited to. Because I think that's what we mean, and I don't understand what without limitation means. And shall include, but not be limited to is a phrase common in rule drafting. And it also reemphasizes the point that not only are the things you're including here must be included, but depending on the particular engagement, it's my understanding you guys are assuming that folks might have to disclose more because all relevant circumstances and reasonably foreseeable adverse consequences are going to change. You can't have a form disclosure for that. It's going to depend on the circumstances.
Exactly. Yeah, that's true.
Greg, can I suggest that instead of going through each one of these and asking if we really mean it and if we really want it, that we just ask generally if there's certain ones that we think people, and
Sure.
if you have certain ones that you think maybe shouldn't be included, that would be great to get us started, or if anyone does. But we've spent a lot of time on this rule, and I think we feel that these disclosures are important in this rule, in the informed consent rule. So maybe we can just focus if people think after review, any of this should come out generally. I do have some comments on some of them, but I do think that's probably the first question.
Okay, let's do that then. I'm all in favor of moving more quickly. Okay, so number 4, we should probably move to that.
But there is a change here, no, in number 2.
Yeah, so we can talk about the changes. I do have some comments and concerns, but I think right now, Greg, you're going through this to say, are there some disclosures that shouldn't be here at all because they're somewhere else? Is that right? Or now that they're here, should
We
they?
haven't had a chance to go through this rule with Kim yet as a
Got
group. So, and she has proposed some changes. So, and as Frida points out, number 2 does include a change proposed by Kim. So,
Right, the with available contact information was my language. It sounds like Kim would like that out. This is an important issue. What I would suggest is that we do open this up. I don't know if today's the right day but make sure that we're receiving public comment on this, and particularly comments from legal services organizations about what kind of disclosures might be appropriate in kind of a simple format, maybe a link to a website, what would be effective, and because we're trying to come up with this. Personally, I think contact information of legal services in the area, it would be important, but it could be standardized.
I agree with Kim. I think this is too onerous here at the Self-Help Center. I mean, I have to assign hopefully an intern and a paid employee at least 2 or 3 times a year to update contact information. I just don't see why paraprofessionals have to be saddled with this. As long as they mention there are other alternatives, really is the responsibility of the client to find out that information, but it's good to inform them. So I agree with most of this paragraph. This is too onerous, this is too much.
So Greg, to try to move us along, is it possible when you do the version of the rules, I know it might mess it up because it's such an unwieldy document, but to put in 2 versions of this subsection, and then for the discussion next week, we call it out, we really talk about it as a full group, because we don't need to have consensus among the 3 of you right now, and we could just kind of move forward.
okay.
I agree with that too, although I think we're 99% in agreement. So I don't know that we need a whole separate set of anything.
And I think it points out the more controversial provisions when there is no consensus. So to the extent that we can kind of clarify what we agree on, I think we should. Just a recommendation. I'm flexible. I think it's more helpful to the full group also.
But I would like to make the comment, I do think before we finalize this, especially with the full working group, we should allow meaningful opportunity for public comment, because I'm sure there's a lot of people who would care deeply about, what alternatives are being disclosed.
Well, I think we're going to post these full set of rules hopefully by tomorrow. So I would hope that, and please do make outreach if you can to public, to legal aid groups that you have contacts with to review the rules and provide public comment, because.
And we do have a little bit more in the notice to the consumer that FREBA added, which was really good, giving them just a little bit more so they would have that information up on there. And so then we leave it to them to find those services.
Mm-hmm.
And
Okay.
to that point, should we align number 2 with what's in the notice to consumers, or?
I think what we have in the notice to consumer, I'm going to come back up here, is number 4. There may be other alternative choices available for a prospective client to consider, including but not limited to free consultation, limited scope services from a lawyer, free services from self-help or family law facilitator's office, or potentially free legal services from a local legal aid organization if the prospective client qualifies. And this is going to, I would imagine they are going to lift this sentence from the rule and put it into the disclosure if we are not, in fact, providing just a form disclosure document, notice to consumer document. So they will be made aware generally that there may be available choices. I think what Amos is saying here is they need to go a step further. Now we're further down the road. Now you know a lot more about the client and what their issues are and what the matter is, and that the paraprofessional should start gathering information about the available choices for obtaining legal services and provide that information to the prospective client.
Yeah, so I agree with that, except I don't think there'll be any gathering. I don't think we'll be doing gathering of information on every case. I think they'll be in a certain geographical location. And so at this point, they will know what the case is about. They will know more about the client and probably have a pretty good idea if there is a free legal service that may be available to them.
So I agree with all of that, but just don't think this provision addresses what you're saying. So for example, one way to look at it is if the paraprofessional knows this person is here for modification of child support, family law facilitator's office provides free assistance with modifications. This doesn't say that. So if you're saying now at this stage, now they need to provide tailored information, referral information tailored to the particular issue, then I think we have to change this. Or if not, then it should be harmonized with the one above, say exactly the same thing.
So what I believe, Fariba, is it needs to be more tailored information, but I don't want to go to the level that they have to make any kind of decision or determination that in fact services are available. It's just that if, for example, for the facilitator's office, if they know your case, that's a perfect example. They should have to say at this point, I'm happy to help you. I think you should hire me. I would do wonderful, but you should know there are free services available to do this that you qualify for. And here's the phone number.
So where does it say in here that is tailored information tailored to this particular customer or sorry?
That is the informed consent part. That's why this is not a written disclosure only. It's tailored. So can we just, before we go too down in the rabbit hole on that, do you agree that in the situation where at this point, so this is after they've sat down and consulted or at least have more information, if, for example, it was something that was within the free services available from your office, facilitator's office, that it should be disclosed that those services are free and available and here's the contact information? Because if we have agreement on that, I think it's easy to fix.
Yeah, I started with that. Yeah, I said I agree with all that.
Okay. So Kim, do you agree with that as well?
I don't believe that you should be tasking them with getting all of the contact information, numbers changed. I believe that they should be providing, there's other services out there to you. Here's like going back to the original, you know, the one before, here's some of the services that are there, but I don't believe that it should be up to a paralegal to have to be a reference service. That's where I'm coming from, and that's why I took that out.
And one thing I want to emphasize again is these are disciplinary standards. So to the extent the paraprofessional gets it wrong, they miss one of the available choices that could have been available, they are subject to discipline. And if they're not subject to discipline, it doesn't belong in the role. That's the thing.
Yeah, and that's where I agree that with what's up in the notice. And now that I'm hearing you guys, so this, including in the written consent, impose a whole different level of this, I don't even know what to say, responsibility subject to disciplinary rule. It's just really, it just doesn't seem right to me.
Okay.
Just to
So in
be
the
clear,
interest of moving forward, I would suggest what we do is offer this as an alternative for the full working, as Leah suggested, so that we can start moving forward. Say that, I mean, Amos, you feel strongly that this needs to be included in the informed consent. I think we bracket it and say this is an alternative that a subcommittee member is recommending, and there is not consensus, and see what the full working group thinks. Does that make sense?
Yeah.
And I can remove the since it's your the option that you want to present, I can restore the with available contact information.
I'm fine with that. Yeah.
Okay.
So the only thing is, I thought this is what you were saying, Fariba, in the no disclosures section, there's reference to self-help and the family law facilitator, and there is not here. And it does seem to me that those aspects of the two provisions, just the listing of the potential other services, should be consistent. I thought that's what you were saying initially, Fariba.
So yes, I'm just saying it's a different version of it and doesn't make sense to me.
Yeah, no, I agree.
That's
That
fine.
part is like,
That's fine.
there's a bigger question.
Them.
Yeah.
Yeah,
I think that's
there
the
is
only
a two.
reason that they're not consistent is because we didn't get to this rule since we changed the other rule and actually went through the rule. So
Okay.
I think adding it in here makes it consistent now. Okay. Okay. So can we move to 4? Because that's where Kim has also made a substantive change to what you recommended. And just to be clear, I think Amos, what you had bracketed this to just say there should be disclosures that are tailored to the practice area in which the paraprofessional is operating, and perhaps we need to essentially task each of the substantive area subcommittees with perhaps considering what disclosures would be needed to apprise the prospective client of the limitations on their practice area. Kim has more generally stated, I think, that it should be a statement that identifies the area of law in which they're licensed to practice, any prohibitions in that specific area, and how these prohibitions may impact the matter in which the client is. And I think this is the part you're not 100% comfortable with, Kim, is contracting with the paraprofessional.
Yeah, I didn't like the way that last little part was worded. That may impact what I was trying to say. It's specific to this, this specific case, but I didn't know how to say that. But it doesn't matter because I think that's what it's called, in which you're contracting with this individual.
Mm-hmm. Does anyone have feedback on Kim's?
So at this stage, the paraprofessional has all the information they need to decide if they can take the case and what limitations apply, correct?
It should.
So why can't they just say, you're hiring me to I don't know, file, represent you in a UD case as a tenant. And my only limitation, of remembering correctly, is I can't represent you if it goes to jury trial. I may be wrong, but anyway.
I think that what Kim is trying, and Kim, correct me if I'm wrong, but in this part that I just highlighted, I think this is what you're trying to get at, which is, this is the area of law I'm practicing. These are my prohibitions, and this is how those prohibitions may impact my representation of you in this matter.
Right.
Yeah.
That's
Uh-huh.
So it should be easy to do this, right? At this stage.
I would hope so.
So I think we're all on the same page. I don't have any problem with Kim's language. I think we're on the same page, except I think we need to provide help here. We need to provide specifics. This is again saying you need to disclose all the risks, but we need to identify what the risks are going to be in every, unlawful detainer case. There are certain risks that are applicable and we should identify them. I don't think our committee's ready and able to do that, but I think other committees might be. So that's why I don't have a problem with this language, but I don't think it goes far enough. Like your example, Fariba, in a eviction defense case, it is relevant that they can't do jury trials. They can't do trials. That's an important disclosure, and that's going to be an important disclosure in every case. We heard at the last consumer debt and general civil of specific issues there about no counterclaims, no litigating predator harassment issues, no federal claims. Those are limitations on the program that are going to be relevant or potentially relevant. And I don't think we should just have ambiguous language. You need to disclose all the risks and how they're relevant. I think we should be helpful about the specifics.
You could add a comment to provide illustrative examples. The burden is you don't want it to be misleading that it's comprehensive, but it could provide guidance to these people as to the type of things they should be thinking about. Conversely, if you try to do the whole list for every practice area in the rule, that's just going to be a headache and a mess. So
it is. It's actually not the role of the rules either.
No.
The rule is supposed to state a general standard, and
That's
then the commentary can provide that sort of interpretive guidance. We can do it through ethics opinions as well. But in terms of making sure it applies in every circumstance to each license, it overburdens the rule at a certain point. So
a potential compromise might be a comment or two that provides illustrative examples.
So I think the rule has to be clear, that the whole purpose of this is that it needs to be clear to the consumer when they're entering into the engagement, what the paraprofessional can and can't do. And we're just fooling ourselves if we think we're making any kind of consumer protection or public protection, if we have some ambiguous rule that doesn't make it clear that the paraprofessional needs to get informed consent, and it needs to be clear what the paraprofessional can and can't do.
Is it possible to require that at this stage of the game, because they know what the issue is, that they attach, for example, for family law, you know how we have included, excluded, included, excluded, like a long list, attachment A, that Amos, you want it to revert back to that instead of just the exclusion list? Would it be helpful or possible to require that they attach that list that hopefully we're going to come up with for every topic?
So possibly, but again, this is why it's different to just say, you can't take a piece of paper off the shelf and hand it to them and be done with informed consent. Those could be required disclosures. We could have a required disclosure that, you know, is a form. But in this is your example, Fariba. They are taking on a case and they know there are certain things they can do in the case and certain things they can't do. That needs to be, you know, told to the consumer, and the consumer needs to understand that before they hire them. That's the point.
What about adding to the disclosures a set of standard forms that are documents that outline, and I think Fariba, it is always going to be excluded because of the concern about not being able to be exhaustive on included, but that outline the scope of practice generically. And then in informed consent, there's something about you need to have explained what that the limitations on the scope of your license, the potential impacts of that on the particular matter to the client. Like, so we've given you the standard form as part of the disclosures, and now in informed consent, the requirement is that you've explained what that means to the client. What about that?
Leah, when I wrote it, that is kind of exactly the path that I was trying to go down. Like, here's the first thing is that you have to explain what you can and can't do. And then the next thing, and that could be a standard form to show like, these are the things you can and these are the things you can't do. And then that last phrase where I'm struggling with the wording of it, is the point to say then, now this is how, because you've explained this whole case to me and this matter and everything I'm going to be doing, this is now how it's going to impact potentially in this case. So that's exactly what I was trying to do. It's just not worded well.
I see it now. No, it is worded well. I just didn't read it carefully.
So I think we're all on the same page. I think we all feel like informed consent is necessary. I think that's what informed consent means. And the question is, how is it going to work in practice in a family law case? What's that disclosure going to look like? And can we make it simple and straightforward? We don't want it to be complicated. We don't want it to be, here's a book or here's a site to the rules. We need it to be a conversation to say, you know, hire me, I can do this, but I need to make sure you understand I can't do that.
But I think in thinking of all the areas, I think family law is going to be most complicated because you could have a divorce case, no minors, right? And there is short-term marriage, but there is a pension. So a quadro is going to be needed. We know quadros are excluded. That one's going to be easy. I can envision a very specific disclosure that says I can help you, but I cannot help you draft a quadro for your pension. Exactly. But if you got a family law case with a divorce, with children, long-term marriage, a pension, house, this, that, the other, now your disclosure is way longer because the chance that many more tasks are excluded is much higher. So
the relevant circumstances and the reasonably foreseeable adverse consequences are going to change depending on what you're being contracted to do, not just in the subject matter area. So
there's limited guidance we can provide here.
Exactly.
What do you think of the language that I provided here?
Got to be careful.
Is everyone in agreement, or what do you think of how these prohibitions may adversely affect the licensed paraprofessional's representation of the client in the matter?
Yes, that's what I was trying to say, Greg. That looks great to me.
Okay.
I think it's doable because then they can, even in the complicated family law cases, they can just point out Because the tasks that are excluded list was way shorter than the tasks that are included, so.
Okay.
So I'm in agreement too. I just think we need to provide some help to paraprofessionals to be able to do this in practice. And the first step in that is to have an understanding of what the exclusions are and how they could impact cases. And I think we go back to the subcommittees for that.
And I really think the licensing subcommittee is going to have to really think about that, because this is something they're going to have to be trained in. Because the standard for lawyers for conflicts of interest, current conflict of interest among current clients, it's pretty generalized in terms of a standard, and the disclosures that you're required to obtain will really be different depending on the circumstances, and it should. So
I agree, but again, here we have some specific exclusions, and I think we can predict how those are going to play out in many cases. So whether that's in comments or in forms or trainings, I think we need to help people get this right.
Agreed. Okay, so let's move on to 5, because we're already at 45, almost 50 minutes in. And I just want to make sure we get through this. The existence of any financial arrangements related to the representation. I've struck referral fees, or because we have decided that referral fees will not be permitted. And thank you, Steve Fleshman, for catching that. Kim's comment here essentially was, is this part of any other law that requires informed consent? And my response, I think, in email was yes, actually. Fee sharing is something that needs to be disclosed, and you need to comply with Rule 1.5.1. That's one type of financial arrangement that could affect representation. There's also a Rule 1.8.6. You need to obtain informed consent and comply with that rule if you're accepting payment from a third party for representation. And that's to preserve the attorney-client relationship and make sure it's not the lawyer's independent professional judgment is not being affected by that third-party relationship. I suggested that we keep this in the way it is, because I think any financial arrangements can encompass many other things beyond the scope of those 2 particular rules. Although we could either in the rule itself or in comments highlight the fact that those are the types of arrangements that should be disclosed, and you must obtain informed consent pursuant to those rules as well.
This is probably a very stupid question, but is fee sharing in general and then referral fees specific to this client, right?
I'm not sure I understand.
So fee share, is this specific to each client, or just in general if the paraprofessional is engaged in fee sharing in general?
No, specific to this client. It's related to the representation.
Okay.
So it's specific to the representation. Okay. So, but if there's any other financial arrangement or that is related to the representation that the client should be aware of, they must disclose that, and that may change again based on the relevant circumstances.
Okay,
Greg,
and an
thank
example
you.
of that would be what? Like if the sorry, Steve, didn't mean to interrupt you, just finishing. So if a paraprofessional owns a firm, if we get there, with a lawyer, right? And the lawyer may take on representation at some point because the paraprofessional cannot represent, it gets too complicated. That has to be revealed here, that there's a possibility.
Yeah, and that's that you're required to disclose that under Rule 1.5.1 anyway. So that, and I think that's what Kim was getting at, but I don't see that it being, I mean, normally we want to keep these rules as lean as possible and make sure that each rule does its own job. But it doesn't bother me personally, and Andrew may have a different idea on this, but to be belts and suspenders on this one. Just to make clear that these things need to be included in the informed consent.
Just really quickly, this does kind of bother me because the informed written consent is to disclose, as we discussed above, and the predicate, subparagraph A, the material risk for entering engagement with a non-lawyer. This provision 5 is governed by, as you say, 1.5.1, 1.8.6, 1.8.1, and 1.7b if you have a personal interest limitation. So I don't understand, this seems kind of off in left field, why this financial arrangements, relay the representation would be here, because any of those disclosures would be obligated by, at minimum, 2, if not 4 separate rules. It just seems, it doesn't seem congruent to me.
And I
Right,
didn't have
this
a
is-
problem. Oh, sorry, Steve.
Go ahead, Kim. I'm the interloper here.
I was just gonna say, I don't have a problem leaving them in and being belts and suspenders, Greg. I mean, that's fine. I didn't want to, I thought by putting it in here when there could be other potential things they have to notify about, why this one was, it is it's very important, but I didn't want them to think like, oh, well, I have to put this in here, but I don't have to give these others. I didn't want to confuse them. That was kind of it. Like, are there other things that they also have to provide informed consent on outside of even that? And why are we just listing one? But I'm okay with it too. I don't have a problem leaving it in there because it is something that's very important.
So just so we're all aware, they would have to get the informed written consent here, as well as the specified consent under 1.5.1 when they're going to take on a proportion of the services that they're sharing with another person, or where on top of the written disclosures. I mean, we're talking about four disclosures at some point.
I wasn't aware of that. I just, again, too onerous here. Come on. Isn't the point to get the information to the client and to get their informed consent? Is it true that if we add this, we now needed 4 disclosures? Is that? No, I'm saying Andrew's lying. I just like, it seems ridiculous to me.
I was not reading it as requiring 4 disclosures. I was reading this as requiring that any of those disclosures that are mandated by other rules or any financial arrangements that's related to the representation must be included in this document. But if it's included in this document, that discharges your obligation under the other rules. And if we need comments,
Okay.
a comment on
That would clarify for me.
yeah. But I think my understanding is that we wanted to make sure that it appears in this document so that you're not obtaining the informed consent in compliance with this rule and then coming in later and saying, oh, by the way, I'm sharing fees with this person and you need to sign this too. So that the disclosures that the client needs to have in order to consent to the representation are all in this one document.
Greg, this is Steve. Thank you for eliminating referral fees. I understand your goal today is not to discuss the merits of fee sharing.
Well, we're trying to get through this particular rule and we've already covered the fee sharing. So that
right.
Yeah.
Then my next question would be, as unlikely as it may be in the paraprofessional program, something like litigation financing would be relevant under this rule. I think someone said, what's the need for this rule if it has to be disclosed under some other rules? And that's just one that popped into my mind. So I think there is a need for this rule as a catch-all, and litigation finance is the hot one today. In 5 years, it'll be something else.
Mm-hmm. Okay. So where does that leave us as a group? Are we happy with keeping it in? I know, Amos, you probably are.
Yes.
So within your rule. Kim and Fariba.
I'm okay leaving it in, Greg. I guess I'm still worried about that there's a lot of other things, right, that they have to potentially provide consent on. Is that true?
I will just comment on that if I may, that this rule would not in any way relieve any responsibilities under other professional rules of conduct. This is a informed consent requirement. It's just an additional rule that makes sure that the client is making an informed decision, and financial arrangements are something that would need to be disclosed if they exist in connection with that. Doesn't relieve any other obligations under the rules.
And I'm just wondering if we need to have another statement in there, if this was going to be one in informed consent for everything, like you just said, Greg, like everything would be in this one now, that if we should put as a final as number 8 and any other disclosures that need to be made. That was the only thing I was thinking, but I'm good either way.
And just to clarify, if number 5 stays in here, they wouldn't have to do the same thing under other rules, right?
We would need to make that clear under the comment that if you are required to make a disclosure and obtain informed consent under Rule 1.5.1 because you're in a fee sharing arrangement related to the representation, and you make that disclosure in compliance with 1.5.1 in the informed consent document that's required here, that discharges your obligation under Rule 1.5.1.
Then I'm okay with it.
Me too. I'm fine.
Thank you.
Okay, and nobody has any thought about whether or not this this seems to belong in the informed consent in everyone's mind, I believe, rather than the written agreement. The next one, reasonable estimate of fees and costs of services to be provided. This is something that at least in my mind, we're already requiring that as part of the written agreement. Whether or not that actually belongs in the informed consent as well.
That's a great point. I think it should be in the agreement because that's more related to the written agreement.
I'm fine with that as well.
Okay.
Yeah, my note was it should be a 1.5.2.
Okay.
Me too.
Okay, good. And then the last one, I think it's the liability insurance. I think that's pretty uncontroversial. Knows or reasonably should know that they do not have liability insurance. Although we've changed this, so this is this is different than because I think are requiring, at least in the notice to consumer, that they disclose whether they do or don't have liability insurance. Whereas the informed consent is mirroring the requirement for lawyers. They only need to make a disclosure if they don't have liability insurance. If they do have it, they don't need to mention it at all. So I think in order to be consistent, we would want to change this provision so it's consistent with the notice to consumer that they are obligated to notify based on their reasonable knowledge at the time of the disclosure whether or not they are covered by professional liability insurance, and then also have an ongoing obligation to disclose at any point in the future if they lose coverage, that they disclose that to their client.
I was
I would throw out my idea. I think that none of that should be in the initial disclosures, but instead it should be an informed consent, and we should bring in the bond element into the informed consent, because I kind of feel, first of all, taking it out of the initial disclosures because it's something that is personal and dependent on the status of the individual licensee. And for the most part, we're trying to avoid that in the initial disclosures, although we do have this general description of fees in initial disclosures. But I also wonder how valuable it is to tell somebody about malpractice insurance without also telling them that I have a bond and maybe even explaining what that means. So like if this is really designed to inform a consumer so they know kind of what the risks are, I feel like it should go with the bond. And
so we did discuss this, I think, at length at the last meeting, with the public policy here being that we are trying to encourage paraprofessionals to get malpractice insurance, even though it's not required, and make sure consumers are informed that malpractice insurance, they don't have malpractice insurance if they don't. That does not apply to the bond situation. So I think bond, it certainly could be in the written agreement. They certainly can say it, but as a mandatory disclosure that they'll get discipline over, I don't think it belongs here. And again, might undermine what we're trying to do, which is encourage people to get malpractice insurance. If we say, don't worry, I have a bond, so it's not important about malpractice insurance, I think that undermines what we're trying to do. I will say, I don't think we need B here. I think B for the continuing obligation probably doesn't belong either in the initial notice or in the informed consent, but only if there's an engagement. So maybe that could only be in the 5-point, well, the written engagement rule rather than the other two.
in the, oh, so, go ahead, Greg. It's
No,
okay.
I was just confused by the comment. So Amos, if I understand you correctly, you think that in the informed consent, they should notify whether or not they have malpractice insurance. But in the written agreement, they rule there should be a provision that makes it clear that you have an ongoing obligation to provide notice if you lose malpractice insurance?
Kind of.
So
So I
the
think
obligations
here-
are disjointed.
So here's my comment. I agree with the way this rule reads and the way the written agreement rule reads. The only change I would suggest is I don't think we need B, which is a continuing obligation either in the informed consent rule or in the initial disclosure rule. I think the continuing obligation only comes if there's an engagement. So I think if we just include it in the written engagement rule, that would cover later, during the engagement, a continuing obligation.
Okay. Well, I mean, informed consent only comes if there's an engagement as well, because you're getting informed consent to representation. But my concern is that it's going to be confusing to paraprofessionals because they're going to have two different rules that one has a requirement for initial disclosure and then they have to go to a different rule. And I'm not sure the ongoing obligation makes sense in a written agreement rule, but I'll, it's your recommendation as a group. So you guys decide what you'd like to do with that. So this is what we have, by the way, this is what we have in the written agreement rule. The statement about the bond, but we've removed any mention of professional liability insurance.
When did we decide that?
Oh, I'm surprised. Okay.
No, that was just my recommendation
Oh, yeah.
because it was
That
in
was
the
not-
informed consent.
Mm-hmm.
So I wanted the mention of whether the paraprofessional has professional liability insurance or not in the notice to consumers, because I wanted the client to know that before the client gets invested in the relationship with the paraprofessional. So that's why I thought it should be in the notice to consumers.
It is. It is. It's right
Yes,
here.
so I'm just explaining, I think Leah was wondering
Yeah.
why it's in the notice to consumers.
And actually, the ongoing obligation is also here under B. So,
But I also agree with your comment, like whether that should be there, but I don't have a decision on that yet. But what I was trying to say that is that then in the written agreement, we have notice again about whether the paraprofessional does or does not have the malpractice insurance, information about the carrier and how to file a claim, and then the same information about the bond. And now I'm wondering, we have that in two places. Why do we need it in informed consent? And if the decision is to put in the informed consent, I think it should be limited to if they don't have it. Because now we have it in three places. Oh, I just think it's enough. Do you have a strong position, Amos, to have it in the informed consent if we have it in the other two places?
So I agree with you. The most important disclosure is if they don't have it. So if you would prefer to limit it to that in the informed consent, I'd be okay with that. I think we just decided we should parallel, so it's not confusing to have the same language in the initial notice as well as the informed consent. But I agree with you, Fariba, that the important disclosure and the policy reason why we're including it, both to get the consumers informed consent and to try to encourage paraprofessionals to get it, is the required disclosure if they don't have it.
So just throwing out there, just going through them in the notice to consumers, I believe that it should, I agree with Fariba that upfront, I think is important to them that whether they have it or don't have it at that point, so they can make that decision early on. But I think that B, I don't know that there's a reason for B to be in that initial, because as it's going on, you're going to run into it at the point of agreement or informed consent wherever we are. So I don't know that we need that B section in there in the notice. And then in the written agreement, I don't know that they need to be in both. So I think we should choose one or the other of where the information on malpractice goes, whether it's in the written agreement or the informed consent. It should maybe just be in one. And then the bond, just to earlier point, I think Leah was saying was about the bond. The reason I put it in the written agreement is because you're going over you're telling them you can file a complaint, but I was thinking in the written agreement was where it would be good, because that's where you're telling them, oh, you have to make a complaint. And if something happens, you have this bond, and now I'm signing this written agreement to enter into a contract with you. And I know that if something happens, I have this bond to go to. And that's why I thought it was better in there than in the informed consent. So that's my reasoning behind everything and my thoughts.
And I agree with all of that as well. Thank you.
Okay, so let's see where we are. So it sounds like everyone agrees that B should be removed from the notice to consumer, the ongoing obligation. Is that right?
Yes,
Okay.
I agree.
And then in the written agreement, where are we in terms of including disclosure of whether you do or do not have professional liability insurance in the written agreement or in the informed consent? It sounded like informed consent was what everyone was leaning towards.
I would vote for leaving it in the written consent, excuse me, in the written agreement,
Okay.
but taking it out of informed consent.
Okay.
Now that I've had a minute to think about it.
Amos, what is your position?
I think it should go in informed consent for the reasons I think Kim just explained.
Okay, and Kim, you also believe it should be in informed consent?
I just think it should be in both. I mean, informed consent is okay because you're telling them that, you're informing them of it, and they're being made aware of it. It just needs to be they're aware of it. I don't think that it has to be in the written agreement about that. I think it's fine in the informed consent.
Okay, and in informed consent.
I'm so sorry.
ahead.
I just want
Go
to
ahead,
point out that now this is the third time we're reminding him of that, just like I'm not a lawyer provision.
It would be, if we take it, I think what both Kim and Amos are saying are either, well, at least Kim is saying either in the written agreement or the informed consent, but not both. And Amos is agreeing with that, and he has a preference for it being in the informed consent.
So we leave the bond in the written agreement, but take out that's so confusing because, one after the other, name of the carrier, if they have it, and how to file a complaint. But now we're pulling out the malpractice insurance, especially if they have it. I just think it has better flow for a client that says, okay, you have a bond and you have malpractice, or you have a bond, but you don't have malpractice. It's just a better flow in the written agreement, but I can talk about that to the group.
Well, and one thing, just for Reba's point, I'm just thinking more about this, is that the B section, that if something changes, that almost should be in the written agreement, because that's what you're both signing off on, right? That this is what happens in the future. So maybe it does fit better into the written agreement than actually having it, and having them all together in that than in the informed consent. I'm not really wedded to either of them. Just, I don't think it should be double. That's my biggest issue.
Well, the policy for the attorney rule, it's just written disclosure. And the policy for having B, which I think is an important aspect, because whether or not you maintain the insurance can change. And so
Right.
B is important because it's an obligation on the licensed professional, whether it's a lawyer or paraprofessional. You're not off the hook by disclosing what the status was at the time of consultation. So
think
if
we
you
all
really
agree
want to
with that.
protect the client, it should
think
be
we
in
all-
written disclosure, because if you put it in informed consent, this statement alone isn't enough. You're going to have to add another sentence or two of what that means, the reasonably foreseeable adverse consequences. I could screw up on your case and you could come after me and I won't be able to pay you for the damages I caused. And it's a much simpler and neater way. I know you guys really want to protect the clients. I just wish you would have faith in rules that are out there. And I think the disclosure rule with B that exists for lawyers, if you put it in 1.4.2, at least at the outset, if we see that there's, increased harm to clients, we can always modify these rules in the future.
So are you saying that you don't believe it should go in the written agreement in 1.5.2? It should go in the disclosure rules under 1.4? Is that right?
That's correct. That's correct.
I agree.
And I don't think it's informed written consent. I don't, I mean, if you
We
wanted
have-
to
we
do
have
that,
heard-
you'd have to beef it up.
We have heard you on that, I think.
I'm
you.
just wondering, I agree that it should be somewhere. It's just notice to consumers, to me, again, just, I don't mean to repeat myself, but it's just things consumers should know before even starting to talk. And then written agreement, things consumers should know before engaging the paraprofessional. So I totally agree with the importance of this provision. I just don't think it needs to be in that first 3 minutes of a conversation with a client. I just would advocate for it being in the written agreement and not in the informed consent.
Okay. So it sounds like both Kim and Fariba think it should be in the written agreement. This disclosure, it already is in the notice to consumer 1.4.2. We just removed the continuing obligation from 1.4.2. Andrew's advocating for you to reconsider that and put it back in there. And I don't know if anyone has strong opinions about that. And then Fariba and it sounds like Kim, this was Kim's edit, but we will reject that. And so to include a statement in the written agreement that whether or not they have professional liability insurance.
Can I clarify, please?
Sure.
I was actually recommending that B from notice to consumer be moved into the written agreement. Is it
Okay.
already there? I'm not seeing it.
Yeah, we
No,
need
it
it
is
once.
not there. It is not there.
I think we need it once. I just don't think we need it 3 times. So
Right.
I agree.
So
Well,
I
I agree. I agree.
yeah. We
Can
need
I-
it
can I just
once.
Advocate for it being in 1.4.2 as well, because the first time you're disclosing whether or not you have professional liability insurance should be the time that it should be in the same rule. That's the first time you're obligating the paraprofessional to do this. You should put the continuing obligation there too, because there conceivably you could disclose I have professional liability insurance and then lose it before the written agreement, but they're not under an obligation to disclose it until they enter into the written agreement to representation, and representation has begun. As opposed to having in 1.4.2, you have the initial disclosure that you need to do before consultation, and the paraprofessional should be aware from this point forward, at the very beginning, you have a continuing obligation if anything changes on that.
So I agree. It should be with the first time it's required to be disclosed. I think Kim and Fariba want that to be in the written agreement. So let me say this. If it is included in the informed consent requirement, I agree there should be a B there as well. But I think where we are is that's the dissenting view, and Kim and Fariba think that the disclosure goes in the written agreement. And then I think we need the B there.
So you want the B and the written agreement. Okay. Okay.
So Greg, are you saying though, so I see this person the first time and then maybe they never call me again. So I would have to call them and just to say, hey, well, I know you're still considering this. And by the way, I don't have in malpractice insurance now.
No,
Well,
I don't.
it's to where I'm saying, like, to give it to them up front. And then when you come in, oh, I see what you're saying though, because if anything
formed.
changes in between then, really when you need to know that actually is.
But
So
by
it says
including
here,
it in the
just to
written
point out what
agreement,
you were saying there, Kim.
Yeah.
The language it contemplates that this is an ongoing obligation only if a paraprofessional client relationship is formed.
Right.
So if they come in to consult with you, you say you do have professional liability insurance, and you never see them again, and you suddenly lose professional liability insurance, you do not need to go through your Rolodex, if anyone has those anymore, and start calling prospective clients that have no interest in engaging you and saying, oh, by the way, I no longer have professional liability insurance.
And
That's
that's
not,
the way that reads.
well, it
'Cause
says
it says any
provides notice
prospective
to,
client.
and a licensed paraprofessional relationship is
Oh,
formed.
is formed. Okay, I missed that.
so
Sorry.
you're saying, let me make sure, an example, client comes in, does an interview or calls, done. And we don't have B. Let's say we decide not to have B in the notice to consumer, right? Then the client calls in, I want to hire you. So if we include it in B, include B in the notice to consumer, you're saying the paraprofessional has to say, oh, before I make an appointment, I got to tell you, I no longer have malpractice insurance.
You
Versus
would,
if you put it in the written contract only when the client comes in to sign the contract, or is, virtually signing a contract, is going to be in there. What's the benefit? I don't understand. I mean, before hiring, they're going to have to sign, before hiring the paraprofessional, they're going to have to sign that contract that has this statement in it, and it imposes that obligation on the paraprofessional. What's the advantage of having to communicate it within the first 3 minutes of the first contact?
well, I mean, I think the people that advocate for that that's an important piece of information that that consumers should have immediately to know whether or not they want to engage this person. I'm talking to somebody who is uninsured, and it's something that if I was working with a contractor, I would want to know if they were not bonded, or uninsured. And so, I'm not advocating for this. I'm just, trying to state the policy argument in favor of making sure that you disclose this immediately when you start talking to someone. By the way, I carry professional liability insurance up to X amount, and I'm required to disclose that to you. I'm also required to disclose I'm not a lawyer. So there is a credible public policy argument in favor of requiring it in a notice to consumer.
So the obligation is to say, I have professional liability insurance. And by the way, if I lose it between now and when you sign me up to be your paraprofessional, I have to let you know. Is that why you want to include B in here?
No, so I'm sorry. So the B is not something that needs to be in the notice. B is informing the paraprofessional, hey, by the way, remember when you notified that person that you had a professional liability insurance? Well, if you lose it later and you become their paraprofessional, you have to disclose when you lose it within 30 days in writing to them.
Okay, I think.
Yeah,
I
so
see.
it
I
becomes
was
an
confused.
ongoing obligation. That's what the
I'm
rule
so
is.
sorry, Andrew. If I would have listened to you 10 minutes ago, we would be done. I totally agree with you that B should just be in 1.4.2. It doesn't have to be, because it's not going into any document. It's just if something changes, you have to notify your client.
Yeah.
Exactly.
I got
It's a
it. I'm
disciplinary
sorry.
standard. It never,
Thank you.
yeah, we don't talk about it.
So
Yeah.
I agree with that, except Kim, I think you and Fariba said that you don't want this disclosure in the informed consent rule. So
I
B
don't
doesn't,
think it needs to be, because it's telling the person way up there, for any time. Now it's not something that needs to be in anything. It's just if it changes, then you have to notify them, right? And then that's going to be for the entire course of your relationship with that person. And you'll be able to take disciplinary action against them if they don't, because it goes back to that first 1.4.2. If anything changes through the whole time, I don't think it needs to be anywhere else. That's what I'm thinking now.
so I agree for B.
Yeah.
But does it make sense to have B without the disclosure that it relates to? So shouldn't there be a disclosure in the informed consent rule, 1.4.2, of whether or not they have, and then the obligation not to change it?
Yeah, in 1.4.2, you need both sections, right? I have or I don't have it, and if anything changes, then you have to notify them. Yes.
Yeah.
I agree with that, yes.
Yeah.
But not in the informed consent.
Written
But it will be in the written agreement, according to the way we have it now. So in the written agreement, you're confirming once again whether you do or do not have. Okay, all right, that's good. I think we are done with the rule. Let's see, we'll remove this and this. Whoops, and I think we're done with this rule. I feel like we should have a bottle of champagne or something. Okay. Let's move. Can we move on to the other rules quickly? Well, not quickly. We will take the time that we need to take. Okay.
Before we do that, could I make a quick comment on 1.4.2?
Sure.
So I think I have just two quick comments. For 1.4.2A2,
Okay.
I think, again, we lost some of the language that I had in. I don't know if it was intentional or unintentional, but it should be at the end, provide all services that a lawyer performs in this area.
cannot provide all services, all legal services?
Sorry, I'm looking at, so I'm not making that change, but I don't oppose it, but all services that a lawyer can provide in this area of practice is the language that we had. I don't know, Kim, if you deleted that on purpose or if that was just you were working off a different draft.
I actually didn't touch that section. That's what, when Greg sent it to us, that's where that came from.
Right, so I don't know, Greg, where that got dropped
Yeah, I
off.
don't know where it went either, but
The other thing is in B, I think that now should read A6 instead of A7. Just a typo.
where's this?
In the paragraph B, when it refers to in the second line,
Oh,
it
yes.
says it should just be A6.
Thank you. Okay.
And my comment is the same, and this is just for A4. I think we should get comments from legal services and others, but that's the same language as the other one. So hopefully we'll be able to get more comments on the alternatives.
Yeah, and I encourage you, again, reach out to your contact people and
Okay.
have them bring public comment.
Could we go to 1.4.3A3? Should that say potential need to hire a lawyer or another paraprofessional?
That was in an earlier draft, but again, I think we deleted that on purpose because
Mhm.
we're trying to make this as simple as possible. And technically that is true, but in terms of having a meaningful disclosure, so a layperson could understand what the risk is. The risk is that they may need to go out and this will go beyond what a paraprofessional can do. And they might have to hire a lawyer, as opposed to the technically true is I as a paraprofessional could do it, but I don't want to. That is a technical possibility, but I don't think that's sort of a minimum standards of discipline that we should require that.
I don't have a strong position either way, I suppose.
Okay. All right.
I'm sorry,
Edith,
Greg,
now- Go
one
ahead.
more time on, can you scroll up just
Sure.
because now I'm looking at just what Amos just recommended we change all the way up to 1.4.2. I think there was something missing because now I don't know that it makes
1.4.2.
what the second phrase in there. So it says the licensed paraprofessional has a license to provide limited legal services. That's right. And then it says the area to which the licensed professional, but there's no,
Oh, yeah.
something's wrong in that one
Yes,
from what
happened
we,
to this one. I don't know what happened.
Yeah.
Even when it got carried over from some of the edits.
I think I just had the area of practice, but I think that additional language is fine if you want it, Kim.
Has a limited, is a license to provide limited legal services. Well, so what are you suggesting? I'm sorry, the area of practice, comma?
I'm not sure because I'm trying to go back to the old language. I think something got missed out of like our earlier ones when,
I think it just said the area of practice and you added some language.
Yeah, I did add language. The area of practice didn't make sense to me because I didn't know what that meant. The area of practice in which they're licensed, or it feels like there needs to be some, because I mean, I just want to make sure that what we understand what we mean by that, because if we're saying area of practice meaning the family law space, which is covers your entire license, or I only do a specific thing in family law, and that's my area of practice. I mean, I just want to make sure that we're clear on what exactly we're requiring them to disclose.
So the original version was that the paraprofessional has a limited license to practice, the area of practice. So it was kind of continuing from a different sentence. Then
Yeah.
we all changed it to what it is now. So the area of practice no longer makes sense.
It should be the area of practice for which they are licensed, right?
Yeah, it needs
Yeah.
something.
Area or areas.
For which, well, it wouldn't be they.
No, the
Yeah.
paraprofessional.
And do we need to just say the paraprofessional instead of saying the licensed paraprofessional has a license to doesn't that too many?
Well, I'm gonna keep using licensed paraprofessional because I'm gonna search and replace as soon as we change the name.
Oh, I see. Okay.
I don't want to have any problems with it.
Got it. I knew there was a reason.
Does this make sense for which they're licensed?
In which, no,
In
the
which.
area in which?
In which? Let's get rid of that. Or
And that the
and
professional.
Yeah, that's right. Yeah.
Okay.
legal services that a lawyer can
all
provide
right.
in this area of practice.
Anything else?
Thank you, Greg.
Okay. It is 4:30. Let's see if we can how far we can get on this work plan. Okay, so do we want to discuss at all the contingency fee cap? Kim and Amos have agreed that they're going to recommend a 33 1/3% contingency fee cap. Fariba, you said you wanted to think about it and come back to it. And I know Steve Fleshman has opined that he thinks it should be 25%.
Honestly, I just wanted to hear the rationale behind choosing 33.3% to avoid being arbitrary.
Fariba, I think 33, I think a third is the standard contingency.
Yeah.
That's the norm. If anything, over time, the percentage has gone up to 40%, but I think a third is considered the baseline, customary and practice.
And often I have seen 30% up to trial, 40% to verdict or something like that, but it varies.
And that's my follow-up question in that, I'm assuming you mean personal injury, 33 up until trial, and the trial goes up. Do we need to provide for that? And then area of specialty is different, right? In family law, you got little hearings that may end in a final judgment instead of a,
Well, Fariba, the contingencies, as I understand,
I'm so
will
sorry.
only
I'm so sorry.
be,
Family law was a bad example. Sorry.
Yeah.
Do we need to have a higher percentage when it gets highly litigated?
my understanding is contingency fee agreements will only be permitted for post-judgment enforcement of judgment matters.
Mhm.
So there could be law in motion, there could be hearings, but there will not be any trials. And I have a understanding that's uninformed, but my general understanding is these things are usually not hotly contested. It really is just a matter of, finding where the money is and attaching that bank account. And I was confused. I thought we voted against all regulation of fees and we were just going to leave it to the marketplace. Did we agree to consider limiting contingent fees?
Yes, we did.
That's
That was set aside as
And
All right.
Fariba, I would, sorry, Stephen.
No, I was just going to say, look, my thinking was real simple. If the standard attorney does it for a third, if the idea for consumer protection is to provide a lower cost alternative, then it should be lower, 25%. I'm not losing sleep over that 8.3% and no one else should. That was the extent of my rationale.
Yeah, and if you're concerned, Fariba, about providing options for it to be higher, if there is some very complicated trial, I would say leave it at 33 1/3 because that is the maximum, right? And so that's the maximum, and a paraprofessional and their client could negotiate a lower percentage.
Okay, and the only other concern I have is very specific to the area of child support collection and the child support private child support collection legislation that does not impose a limit. So we are imposing a limit. So if the enforced judgment that's being enforced is a child support judgment, which the paraprofessional now is putting on their private child support collector hat.
well, then they would be limited by the statute. Is that what you're saying? If the statute limits to a smaller percentage?
No, the statute has actually no limitation.
Oh, okay. I'm sorry.
Yeah. So if they're putting on their private child support collector hat, you know, then which rule are they supposed to follow?
I
Or
think
do we
we
need
talked
to
about this last time. I mean, at a certain point, then this is where 1.8.1 comes into play, business transactions with a client. So my reading, and you have to read these rules all together to understand how that would work, but potentially you're entering into a business transaction with a client, even though you're putting on a new hat. I'm no longer acting as a paraprofessional, but you still need to comply with that rule to the extent that you have a client relationship with that person. And so that means the terms need to be fair and reasonable. So to the extent that you are charging more than 33 1/3%, which it would be your limit if you were acting as a licensed paraprofessional, query whether or not you would be in violation of Rule 1.8.1 if you were to charge more than 33 1/3%, which you otherwise would be limited to.
Right. So I just want to put that out there. But I'll agree to the 33 1/3. I agree with the rationale. It's fine. But I do want us to have that question, and we may have to actually discuss moving enforcement of judgments into its own specialty. Just putting it out there. We don't have to discuss it just because of these types of limitations and crossover legislation.
I'm sure that'll come up in the full working group discussion as well. Okay, let's move on because I just want to make sure that we cover these topics. Trial publicity. Let me pull up that rule so that you can see it. Oh, I don't have my rules up here. Hold on one sec. But essentially, I think Steve had, I think, a very good comment because I think we removed that rule originally thinking that it would not be necessary. I was mostly thinking of it in the context of criminal law because it really was an outgrowth of the O.J. Simpson trial. That's when we really adopted it. The legislature directed the state bar to request the court adopt a rule. And we adopted the ABA, a variation of the ABA model rule on trial publicity. Some aspects of the rule really are geared towards criminal cases, others are not. I think Steve raises a good point that to the extent paraprofessionals are going to be permitted to practice in family law and dissolution matters, there are many of those types of cases that receive a lot of publicity. And the purpose of the rule is to really protect the administration of justice and avoid any prejudicial out-of-court statements. Let's see, I just blew by the rule. Let me reject deletion. Okay, so here's the rule. It's that a lawyer, in this case, when they're participating in investigation or litigation or matter, they should not make an extrajudicial statement if they know or reasonably should know, one, that it's going to be disseminated by a public communication, which essentially means you know that it's going to get out there and the public's going to find out about it. And it's going to have a substantial likelihood of materially prejudicing the adjudicative proceeding. And then B is a bit of a safe harbor. It allows and to the extent permitted by your duty of confidentiality, which is 6068E, a lawyer can state, and this is where some of this really reads to me like a criminal defense or prosecution rule, that the claim of offense or defense involved. So you identify that, you can identify the people involved, any information that's in the public record, the fact that an investigation is in progress, the scheduling or result of any step in litigation, requests for assistance obtaining evidence or information thereto. And then if there's a warning of danger is needed, you can do that and provide the information that's provided in this provision. In a criminal case, in addition to paragraphs 1 through 6, you can say the identity and general area of residence and occupation of the accused has not been apprehended, and information necessary to aid in apprehension, and the fact, time, and place of arrest, and the identity of the investigating arresting officers. And then C, notwithstanding, a lawyer, this is right to respond, essentially. A lawyer may make a statement that a reasonable lawyer would believe is required to protect their client from substantial undue prejudicial effect of recent publicity not initiated by the lawyer or their client. And the information that they provide should be limited to what is necessary to mitigate the recent adverse publicity. And then this D just extends it to everyone in your law firm. So that's essentially what that rule does. I think we would have to make some correction of some probably deletions to this rule to remove the references to criminal cases, or at least conform it somewhat. But I wanted to bring it before the group and see what you're thinking about this.
I agree with Steve that we likely need it or want it with modifications.
I do too. I looked at it, but that's where I was. It's like some of this stuff, a paraprofessional wouldn't pertain to them. So just to conform it.
And Fariba, are you in agreement as well?
Agreed. Yes, I'm in agreement.
Okay, so I can go through and propose some changes that I think would remove. I mean, obviously, I think 7 would come out.
Yeah, 7's the big one.
And then a warning of danger concerning the behavior of a person involved, reason to believe that there exists a likelihood of substantial harm, but only to the extent that dissemination of the communication is reasonably necessary. I can see why this may be, there's an argument that they may be included, especially if there's somebody who might be an abuser that's dangerous to the public, but I don't have a well-formed opinion on this one.
Greg, aren't paraprofessionals going to be doing civil harassment and domestic restraining orders?
I believe so, yeah.
Then I think you need that. I mean, I can be talked out of it, but
Okay.
Is this, let's see. Is it like a Tarasov warning?
I don't think we need this until we see what the legislature is going to do. Go ahead. I'm sorry, Fariba.
I was just saying, is this kind of like a Tarasov warning? Warning danger of concerned behavior involved in the.
It's not necessarily a Tarasov warning, because Tarasov warning is it's an affirmative obligation to warn people if you believe they're in danger, and it's actually an exception to the duty of confidentiality for psychiatrists, doctors.
Right.
This is different. This isn't to protect necessarily the public. This is the rule, especially paragraph A, is to protect the administration of justice. So we don't want lawyers out there, especially as you can imagine, some of these highly publicized criminal cases. Again, we really realized that we needed to conform to the majority of jurisdictions that already had this rule in place in the course of the O.J. Simpson murder trial, because we didn't have a rule like this. And so the concern was that it was really polluting the jury pool, potential jury pool, with all the lawyers out there making statements that were prejudicial to the other side. And so that's what A is for. B, C allows a lawyer to respond. So if there's been negative adverse publicity, they have a limited right to respond to the adverse publicity, but only to provide as much information as necessary to mitigate the risk of harm.
Should we try to move on?
Yeah, let's move on.
Yeah.
Okay. Work plan. Okay, so let's turn to, this is the rule 1.8.10. So just to give a little bit of background, we were in a minority of states that did not have a bright line prohibition on lawyers having sex with their clients until we passed our new set of rules in 2018. Our rule instead prohibited a lawyer from engaging in sexual relations with their client if it rendered them incompetent to provide legal services, or if they were exerting undue influence or intimidation to obtain sex, or they were conditioning the provision of legal services on sexual relations with their client. We changed that, joined the majority of other jurisdictions. We adopted a bright line rule that you cannot have sex with your client unless it's your spouse or registered domestic partner, or if a consensual sexual relationship pre-existed the attorney-client relationship. We also have a provision, Business and Professions Code 6106.9, that prohibits engaging in sex with their clients, again, that mirrored the old rule. And what we lost by adopting a bright line rule was that our rule currently, and this is probably something we could revisit for the lawyers as well, does not prohibit a lawyer necessarily from conditioning the performance of legal services for sex as long as a sexual relationship doesn't ensue. And so it's a gap that we have here in the rule if we were just to adopt the rule as written for lawyers and not incorporate these provisions from the business and profession code. And so what Randy is suggesting is that under A becomes A1, that really mirrors the rule for lawyers, and then adding 2 and 3, which prohibits a licensed paraprofessional from expressly or impliedly conditioning the performance of legal services for a client or prospective client upon their willingness to engage in sexual relations, or employing coercion, intimidation, undue influence into entering a sexual relationship with a client. So they can violate this rule even if they end up being unsuccessful in engaging in sexual relations with their client, which I think is a sound rule to have. And we'll have to see what the legislature does. This gets into the list of statutory changes. The legislature may simply adopt a version of the rule that the statute that applies to lawyers. But I still think that there's probably much to commend in the idea of modifying this rule to incorporate this type of misconduct as well.
Greg, this is Steve. My personal preference would be to follow the attorney rule. And then when the attorney rule is modified this one. I don't know why, that just is my preference.
I actually disagree. I think we should make the changes that you need to make. And also when you guys talk to, I'm not sure how that works with the legislature and, you know, your laws that we need them to put in, that they actually make that in the paraprofessional, and hopefully then the attorney side would follow. I think it should be clear and no conflict, because it looks like right now between the attorney rule and your BMP code section, there's contradictions from what I was looking at. Is that correct? Like it's not the same, right?
They're regulating different type of conduct. Yes.
Okay. Yeah. I think we should put what we want in here, what protects the client.
I agree, and especially if the attorney version doesn't get amended to include this. This is best practice, and I know there's an aversion to include best practice and rules, but I would agree that we need it, and let's put it in there.
I agree as well. Maybe we could separate it out in a separate subsection so that it's clear that it's doing two different things, paralleling the restrictions on attorneys.
Okay, and I think Brady, does Brady have this on his list of statutory changes also?
I do, and I think that if we have time to turn to my item, obviously we won't get too much of it. There were two others that involved at least considering whether there should be a change to the rules of conduct. So maybe I'll start with those.
Why don't we, I think we have consensus from the subcommittee on that rule. So I'm done with my list of rule issues. We can turn to you, Brady.
You
Greg,
did.
Greg, I think you had 5.3.1 as
Yeah.
What's that? Oh, I'm sorry. I completely skipped over 5.3.1. Sorry about that. Maybe we won't get to you, Brady. Sorry about that. Okay, so I don't know if you all had a opportunity to read the summary of what this rule does, why it exists. It essentially requires any lawyer who employs a disbarred, suspended, resigned, or involuntarily inactive lawyer to notify the state bar and to also obtain the informed written consent of any client that the affected lawyer is whose matter they're working on, that they are suspended, and then it also limits what they can actually do. And including they can't handle funds, obviously. So one of the reasons for the rule is really, it does provide an avenue for these types of lawyers to actually rehabilitate themselves and demonstrate fitness to return to the practice of law. And in order to do so, they would have to file a petition for reinstatement. And the court handles a lot of those petitions on the final appeal as well. But it makes the client aware that that such a lawyer is working on their matter, and also allows the state bar to monitor their activities as well. So one of the wrinkles in this, of course, is that we are authorizing paraprofessionals and lawyers to practice in the same firm, to co-own firms. Lawyers are permitted to employ these types of former lawyers. And so query whether or not we need a rule like this in place, because they may, a licensed paraprofessional may be supervising this type of individual because they are no longer a lawyer. Even though we have a ban on paraprofessionals supervising lawyers, they are not considered lawyers any longer. So you can envision that they might be charged with supervising them as well. And let me bring up the rule so you can see it.
And you already have a law, right, for aiding and abetting unlicensed activity, right? So this
Yes.
is on top of that, basically.
Yes,
Okay.
Rule 5.5 prohibits and it would prohibit a licensed paraprofessional,
Yeah, I
but
thought we
prohibits a
looked at
lawyer from aiding and abetting the UPL. So these types of, individuals are not practicing law. I'll just tell you what they're doing. We call them ineligible person. That's what there's a whole definition section to this rule. Ineligible person is a licensee whose current status with the state bar is disbarred, suspended, or resigned. They can't employ or associate with anyone with if they paraprofessional knows or reasonably knows an ineligible person is performing these types of things. You can't render legal consultation or advice to a client, can't appear as a representative, negotiate, transact any matter, receive, disperse, or otherwise handle client funds, or engage in activities that constitute the practice of law. But this is what they may do. They can do perform research, drafting, or clerical activities, including but not limited to legal work of a preparatory nature, like legal research or assembling data. They can directly communicate with clients or third parties regarding scheduling, billing, updates. They can accompany a licensed lawyer, actively licensed lawyer to a deposition or other discovery matter for the limited purpose of providing clerical assistance. And then these are all the notification provisions that they have to notify the state bar, they have to notify the client, obtain their informed written consent. And then also notify the state bar when they no longer employ them.
So I think there should be a parallel provision for paraprofessionals. Otherwise, I think there's a big loophole for these ineligible people to be effectively practicing law under a paraprofessional's license.
I agree. It's weird to me that there's a law out there like this when they're just kind of doing, as long as they're not practicing law, they could hire them. It's just odd from my perspective of all of our licensees. It's a little bit odd, but I'm okay with putting it in there. The one thing is, I think there are some changes we'd have to make based on this being a paraprofessional.
Mm-hmm.
I agree.
I think it talks about a deposition in there, Greg, on one of the sections, and they can't do that. I think it's C3.
Yeah, they can accompany to a deposition or discovery matter for the limited purpose of providing clerical assistance.
But I thought that our paraprofessionals aren't doing depositions, are they?
No, but so this would be well, this is what we should also focus in on, is that what we would consider to be an ineligible person would be a licensee, which could be someone who's an ineligible paraprofessional or ineligible lawyer.
Right. You'd want to make the policy decision first as to whether or not you want a licensed paraprofessional to employ either and disbarred, et cetera, paraprofessional and a disbarred, et cetera, lawyer, one or the other, and then you would have to draft the rule accordingly.
So my concern from the consumer safety and things that just history with this kind of individuals who are disbarred and or unlicensed or revoked and come into practice usually, I'd be a little concerned about a paraprofessional employing a disbarred attorney. If it's another paraprofessional, they might be able to put more, stops around them, but the attorney one kind of caused me to have some concern. But then you're limiting them from being able to, hire people and have these individuals try to keep in the profession, doing something.
Well, from a policy, so if that was the consensus of the group, you could have that provision that they are paraprofessionals not able to hire a disbarred or otherwise ineligible lawyer. Assuming you're going to allow them to hire a disbarred or otherwise ineligible paraprofessional, as you've already identified, you have to redraft some provisions of the rules to accommodate that. And then for your policy concern that a disbarred or otherwise ineligible lawyer doesn't have the ability to be hired by a paraprofessional, you could point to Rule 5.3.1 and say rehabilitation is available for lawyers to work with other lawyers pursuant to the attorney rule. So you're not cutting them off completely because this policy already exists for those lawyers.
My only concern is, again, with these firms where they're licensed paraprofessionals and lawyers co-owning a firm together, and there's nothing that would bar the lawyer from employing a disbarred attorney. And the rule does say, shall not employ, associate, and practice with, or assist a person that they know is ineligible. And so it may be unworkable not to include disbarred lawyers in that definition of ineligible persons, given those circumstances.
That's pretty broad.
To what extent should, I don't know if you know, but how does this impact the right of an individual to work? So the concern is, I'm totally see it, a disbarred attorney, family law attorney first. I keep going to family, but gets hired by a family law paraprofessional, and sure, they're not supposed to give legal advice and all that, but if they have the knowledge and they share it, so they're kind of are there to give legal advice, and before you know it, it's impacting, they're gonna behave badly. But well, how does this impact their right to work at a job?
You mean if we were to say that they couldn't hire a disbarred attorney?
Mm-hmm. Yeah.
Well, it would
To do anything.
They wouldn't be able to work at those places, and we might see a legal challenge to it based on
right.
Their right to be employed. We have a pretty broad protections in California when it comes to that.
Right. So how do we address that when we're drafting this rule?
Well, to the extent if the group it sounded like the group was recommending that we just have a parallel rule that applies to lawyers applying to paraprofessionals, in which case it doesn't impact their ability to work. They just need to comply. The hiring firm just has to comply with the rule. But to the extent we're saying that we might consider barring licensed paraprofessionals from employing or assisting a disbarred attorney from working in their firm, well then we might have to get a legal opinion from OGC as to whether or not how that would fly, because we came up with against this a couple times in the Rules Revision Commission. The court is loath to adopt a rule that it's later going to have to strike down. So to the extent we're asking the court to adopt a rule that would bar them from being employed in these situations, they would probably want to ask the state bar to take a hard look at the legality of that.
Right.
And that was just me, Greg, when I was thinking, I didn't realize it included such a broad, what all they can do. So I'm okay if just a mirrored section of law as well.
That's what I support as well.
Okay. And Fariba? Okay. Well, now I'm done with my list, and now we're done with our time pretty much. We have 4 minutes left, unfortunately.
So
So,
maybe we can use our remaining minutes just to kind of map out a little bit of a game plan. I want to see if the reg subcommittee members will be comfortable just having Brady present what he was going to do today for the first time at the June 25th meeting, indicating that the regulation subcommittee members have not had the opportunity to weigh in. But because we're not asking the working group to take any vote on the 25th on the Brady issues, it's really just to raise it for discussion. That's what I'm going to propose.
I'm fine with that.
Yeah. In the meantime, if we have any, we review this and have any questions, we can just email Brady. Yeah.
Yeah,
Definitely.
absolutely. And
And
then
I spoke with Stephen, and he pointed to a few areas of civil code where there are many fewer hits, but that he wanted to look at. So I will look at that, and I might send another short supplement.
okay. And then with respect to the rules of paraprofessional conduct. So Greg, you're gonna try to get this all wrapped up today.
well, that's one of the reasons I've been trying to edit and keep the edits up to date as we've gone along. So I will try to put in these final edits based on what we decided today. I will send them, I guess I'll send them to you and Linda, Leah, to send out to the group. And then what I would ask is that the group take a hard look, especially at the rules that we spent a lot of time on, and make sure I didn't get anything wrong. Because as you can see from today, I do make mistakes. So let me know if there's anything that looks amiss. And then once I hear from everyone, either thumbs up or these are the things that you messed up on, Greg, and you need to fix, then I will make those changes. And then I think we should send it out to post it for the public, and also send them out to the full working group.
Right.
So hopefully we can accomplish all that by tomorrow if everyone has time to look at them.
Yeah, that's what I was going to ask.
Yeah.
And then my recommendation is we scrap trying to do a cover memo, because Reba and Amos, you'll recall that was and Greg, it was a very painful process last time. Let's just post the rules and then spend next week via email figuring out who's going to speak to what we want to present. Obviously, we're going to want to present on informed consent, the written agreement, all of that. But what other issues we want to tee up for discussion? Are folks comfortable with that?
Can we post our prior memos? Because I think a lot of this was covered in our prior memos. I just want to make sure that's available to the public.
Sure.
And when you said you'll talk to us next week, it'll be individually, yeah?
Yeah, via email from staff to just try to coordinate an outline for the presentation, because we don't want to go through every single rule. We don't have time. And so we want to lift up those really key issues that you want the working group to focus on.
I think it's important to underscore for the full working group that we were working under the assumption that the disciplinary standards that apply to attorneys provide our floor. Like that's the minimum standards that we expect from paraprofessionals, and there are additional expectations, ethical obligations, and then really go from there and identify what those additional obligations are, beginning perhaps with the notice to consumer, informed consent, written agreement, and then move through the rules. I think 5.4 is going to need some time. Obviously, fee sharing as well, because that is we've diverted quite a bit from the lawyer rule in that regard, and it affects the lawyer rules as well. So making clear that there's going to have to be conforming changes to the rules that apply to lawyers as well.
Can I ask a very quick question? In the most recent table I sent, which was our review of the attorney duty statutes, and in large part, we found that all of them were covered by our paraprofessional rules. One exception was where we thought the sexual relations with client statute should be imported, and you guys voted on that. There were two where we were sort of ambivalent on whether the statute should be moved into the paraprofessional rules of conduct. Those were for it being a suspendable or disbarable offense to basically support an insurrection, which think it's an old statute, but more relevant these days, perhaps. And it being a suspendable or disbarable offense to report someone's immigration status in housing and employment disputes. And so I just wanted to make sure that not having had a decision on that won't put a wrench in your plans to finalize the rules of conduct.
So when do we discuss those? Because that last one
Didn't.
was kind of important.
We
We
didn't.
don't.
We
Brady,
did it. We did.
I personally have to get off now. I
Oh,
don't think,
sorry.
I think that we're gonna have to have it be a wrench and deal with
So,
it.
I mean, it's probably a small bore plugin that we could discuss at a later date. So,
Okay.
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 Right.
sorry.
Sorry, Brady.
Thank you.
Usually
Thanks,
me-
everybody.
Okay,
Thank you.
bye.
Bye.
All right,
Thank you.
see you.
Bye, everybody.